Can everybody see the screen?
Yeah, we can see. Thank you.
Okay, very good. Good morning or good afternoon, depending where you are in the world. My name is Andrew Griffiths. I'm the President-elect of the DRBF, and I'm very pleased to make a presentation to you today. Okay. All right. In my presentation, what I intend to do is, first of all, to give a further introduction to the DRBF, then briefly deal with the types of dispute board, but to focus on dispute avoidance. So I'll deal with the function and the purpose of the dispute board, elements for a successful dispute board, dispute avoidance, and how best to use the dispute board. If we have time, I will do a short summary of the dispute adjudication part, but the main focus, I think, of this presentation is dispute avoidance, because that, to me, is the real benefit of a dispute board. Okay, all right. The Dispute Resolution Board Foundation, the DRBF, is a non-profit corporation formed in 1996 to promote the use of dispute boards worldwide. We have over 850 members from more than 65 countries, and we're very pleased to support SCLVN in this process. We think it is a great opportunity to work together to promote dispute boards. The DRBF has 3 regions. Region 1 is the USA and Canada. If I skip, Region 3 is Australia and New Zealand. And then Region 2 is everywhere else on the globe. It's Europe, Asia, Africa, and Latin America. And we have a system of country representatives to ensure that we can support somebody who lives in a country, promote the dispute board and dispute board practices. Our objectives are, one is to communicate about the process. We publish a practices and procedures manual, which has recently been updated and can be downloaded for free off the DRBF website as an e-book. You can buy it on Amazon for a very small fee. And during our conferences and presentations, we have a hard copy version, and you can contact the DRBF if you wish to obtain one. We publish a quarterly newsletter and other publications. We engage in social media to share information. We provide an opportunity for members to network and discuss issues. And we provide further information and case studies and resource materials. The other objective, of course, is education and training to increase the process, the awareness of the process, educate the industry, that is both the users, in terms of project owners, contractors, engineers, lawyers, and we offer training workshops at all our conferences and independently. And again, we have the procedures manual. Okay, if you wanted to contact the dispute board, join as a member. There are a lot of benefits. That is the contact details. The easiest one to remember is at the very bottom there, where it just says www.drb.org. If you look on the website, there is a lot of information, and hopefully a lot of our participants today will have a look at the information and decide it's well worth joining the DRBF. Okay, so let's move on. I've done the advertising for the DRBF. I'll move on to the content now. I will be covering more general principles, so that Jim Perry, when he takes over from me, he will be discussing some case studies. So I'll just set the scene, and Jim will then bring in some case studies. I'll try and throw in a few comments about my experiences as well. I've served on probably over 40 or so dispute boards, so I've had some practice at it. I haven't got it right yet, but hopefully I'm getting better each time. All right, this slide just covers, for those who don't know too much about dispute boards, you could get very confused by the number of names. And if I just look at the names first, you have a DRB, which is a dispute review board. That's in the USA. Australia either calls it a DRB or a DAB.
Hello.
FIDIC 2017 has a dispute avoidance and adjudication board. The FIDIC 99 suite has a dispute adjudication board. The FIDIC MDB harmonized has DB, which is just a dispute board. The ICC have what they call a combined dispute board, ICC being the International Chamber of Commerce, and the new NEC 4, the new Engineering Contract Revision 4 in the UK, has a dispute avoidance board. But essentially, there are two categories. First of all, you can differentiate the dispute boards by those that make a binding decision on the dispute and those that make a non-binding recommendation. Only. We'll be talking mostly of the FIDIC type dispute, DAB or DAAB, that gives a binding decision. You also have what is termed an ad hoc dispute board or a standing dispute board. An ad hoc dispute board is mobilized only once there is a dispute. The standing dispute board is mobilized at the start of the project, regularly visits the site, is involved throughout the construction process, and obviously the big advantage of a standing dispute board is it has the ability to help the parties avoid disputes in the first place. Whereas a standing dispute board, much like every other form of dispute resolution, is only mobilized once there is a dispute. Right? So it makes it much more difficult to avoid and resolve disputes. All right. The function and the purpose of a dispute board. First and foremost, the DB is part of the, and I'm talking of a standing dispute board, who visits the site regularly. It's part of the project team, okay? And it's there to assist the parties in the performance of their contract obligations and to avoid disputes. In assisting the performance of the contract, it tries to ensure that there's effective and timely contract administration. Need to assist with the early resolution of claims and contractual issues. Avoid disputes. And if disputes do arise, then to give a quick and impartial and hopefully inexpensive decision on that dispute. Importantly, though, the dispute board is not there to do the engineer's job for him. The engineer, under a FIDIC contract, still plays a very important role in administering the contract and ensuring that there is the contract relationship between the employer and the contractor is maintained. Okay? So it isn't supposed to be that the engineer doesn't have to make any tough decisions against the employer and hand it over to the dispute board, or make tough decisions against the contractor and hand it over to the dispute board. The engineer is still there to do his job. And similarly, the dispute board is not there to make a claim for the contractor. The contractors, in my experience, are usually very capable of making their own claims. The DB is there not to make a claim for them. And similarly, the DB is not there to defend a claim for the employer. The employer is still to do that. So the dispute board is there just to, a bit like a good referee in football, is to make sure that the game flows, that it's played according to the rules, that the parties are playing properly, and then to, if something happens, to make a quick decision and a ruling on the contractual issue. All right, so some elements, in my view, for a successful dispute board. Of course, the dispute board members are neutral and subject to the approval of both parties. Neutrality is important. I have heard of some cases where the employer has appointed retired members of his own staff to a dispute board. Well, that is not neutral. And similarly, if a contractor picks a retired director of his own organization, that is not neutral. The DB members are experienced in the type of work and in the interpretation of contracts. The dispute board fees and expenses are shared equally by the parties. Okay? So there you can see everything is kept equal and neutral. The DB is organized when the work begins, before there are any issues or disputes. I think you'll hear later on today of problems that arise when the dispute board is organized too late into the contract. It still means you shouldn't give up on the dispute board, but it makes the dispute board's job much more difficult. That you may arrive on site 12 months into a 24-month contract. Things are going wrong. There are claims, there are disputes. The parties aren't talking to each other. Now you have to try and resolve that issue. The dispute board starts at the beginning. It can help make sure the parties communicate and stay working towards the same goal, which is a successful completion of the project. The dispute board keeps abreast of job developments by periodically reviewing relevant documentation and regularly visiting the site. We'll come along, we'll return to that point later in the presentation. Right, and now with dispute avoidance, excuse me. The presence of a dispute board, just regularly visiting the site, being in place, does help to promote mutual resolution of issues for the parties to discuss and solve the problems themselves. It helps to create and ensure and maintain positive relationships between the parties, to facilitate open communication, and to facilitate trust and cooperation between the parties to the contract. It also minimizes posturing, threatening to make claims or making claims which have no merit, or rejecting claims that do have merit. Okay? Because if things aren't addressed properly and get referred to the dispute board, well, the dispute board will see through problems. If the claim has been made up, the DB will see through that. If the reason for rejecting it is invalid, the DB will see through that. So the presence of the dispute board, just having a dispute board on your project, helps in a lot of ways of maintaining this balance, maintaining the cooperation and working together. So an effective dispute board promotes project management best practices and promotes dispute avoidance. And if you follow those two rules, the chances of your project getting into trouble are much less. I'm not saying you won't get into trouble, but hopefully your chances of it are greatly reduced. So when it comes to dispute avoidance, in my practice, I believe the dispute board can operate on 3 levels, which I'll elaborate on during this presentation. First is an informal operation. Then there's advisory opinions, and we'll come to that in the context of the FIDIC contract. And then structured interventions. Okay. The first is the informal. During the regular operation of the contract, the parties, that's the engineer and the contractor, and the employer, are encouraged to ensure they have a claims register. Any claims for additional time, additional money are put into this register. But the contractual issues, program and progress issues, delays, risks, issues of concern are discussed at each site visit, as well as in communications between site visits, particularly the risk registers and the claims registers. So the risk register is trying to encourage the parties to look ahead, see what problems may arise and how they can best head them off. Claims registers are there and are discussed in detail. These are claims for additional time, additional payment, claims for delay that have arisen. They're discussed to ensure that they are being processed and resolved as early as possible. And in discussion on those claims, there may be questions from the dispute board that may lead the parties to reconsider their position and resolve the issue without further input from the dispute board. It's usually not to spend a lot of time arguing what the merits of the claim is about, but discussing what gave rise to the claim. What are the facts? What are the contractual bases? So you can have a discussion at a site visit. both parties agree, the dispute board can offer some advice, even propose a solution of how to evaluate the claim, how to deal with the claim, the records that are required, and so forth. The next sort of limb is what we call advisory opinions. They're provided for in the FIDIC 99 and clause 20.2 and article 4K of the dispute board agreement. And in my experience, these advisory opinions can be very effective tools. Both parties must agree. That is fundamental. So to ask for an opinion, both the employer and the contractor must agree to ask for it. The dispute board is not empowered to act on the request of one party or of its own initiative to jump in and tell the parties what they must do. It must be asked. The opinion is not binding. So if a party doesn't accept the opinion, it can still refer it to the dispute board for a decision. But in my experience, and I've issued a lot of opinions, only twice have I ever had an opinion become part of a formal dispute. So the opinion should relate to a particular set of facts, a question of interpretation, and the problem that arises from it. And typically, the type of things that are suitable for an advisory opinion are contract interpretation, if there are common issues in a number of claims, time bar, a contractual point or disagreement in a larger claim evaluation. So suddenly the parties are stuck in evaluating the claim on a particular point. The DB can give an opinion to unlock that. I've used it successfully with things like delay analysis, time impact analysis, that issue, and small value claims. So the way I conduct it, and I think a lot of my colleagues do, is first of all, you ask the parties to agree on the question that's going to be put to the dispute board. And a number of times that actually helps solve the problem. The parties provide a brief position paper, 1 or 2 pages, and then you have a brief presentation and discussion at a site visit. The DB can consider the question and give the opinion maybe the next day, if it's relatively straightforward. Can give it in writing within 3 to 4 days, or if it's a bit more complicated, perhaps take 1 or 2 weeks to prepare the decision. But obviously the most effective one is where you can give the decision the following day, and the parties can then get on with managing the contract and evaluating the rest of the claim. But remember, with advisory opinions, both parties must agree to request one. The opinion is intended to give the parties guidance based on a brief, impartial analysis of the problem. It's not binding on the parties, and if the parties cannot settle, then they still have recourse to the dispute resolution procedures in the contract. The opinion is also not binding on the DB, should it become a formal referral. The next point is really what I call the DB structured intervention. And this is useful for very large or complex claims, where along with the DB, the parties can set up a stepwise approach to the evaluation of the claim. So for example, You can take steps on compliance issues. That's the notices, the particulars. Have they been supplied? The contractual basis and the merits of the claim. The delay and disruption, if that is part of the claim. The extension of time and concurrency of delay, and then the quantum and that. And you can take all these steps, and then as the parties are going through them, they can present, explain, and discuss the process and each step with the dispute board. And if necessary, refer and obtain a dispute board opinion before moving on to the next step. So rather than waste time arguing about an issue, you can say, well, let's agree to disagree. Let's ask the dispute board opinion and let's move on. Also, the role of experts in that process, if you've got time or quantum experts. Okay, so that is also a way you can use your DB. Which brings me really just to some pointers for the users of dispute boards out there, contractors, employers, engineers, how best to use your dispute board. Firstly, keep the dispute board up to date with progress and issues as they arise. Use the site visits to fully brief and inform the dispute board. Provide information in advance. So the more your dispute board knows before it arrives on site, the better. Open and frank discussions at the dispute board site visits and meetings. I tend to say that those discussions are without prejudice. And to keep discussion going. All right. Senior representatives of the employer, contractor, and the engineer should attend. People who can make decisions. Adopt a dispute avoidance mindset. Agree to cooperate. Good communication. By good communication, I always remind people that is just not making sure you can talk clearly or loudly, but also you can listen well and understand, fully understand what the other party is saying. Negotiation, okay? The parties are always free to negotiate their own solution. The dispute board, if it gives an opinion or if it gives a decision, must give the decision strictly in terms of the contract. But you can negotiate, the parties can negotiate what they like. And look for solutions that are in the best interest of the project. Refer issues to the dispute board for non-binding advice or opinions. And if there are problems that cannot be resolved, do not delay a referral to the dispute board for decision. I have some where the referral arrives 4 years after the claim event. And that is difficult to solve. So I think with that, I think that's my time is up. I won't go into the dispute adjudication part of it. We can leave that to another day if you find my presentation to be exciting. We can try again. But I think my message is the dispute board is a tool available to the parties. You have a panel of experienced people who can help you solve your problems and ensure that the project flows smoothly